All right, well, you don't usually expect a simple handshake between friends to end up being worth millions of dollars, but that's exactly what's happened in a recent case where a decades-old promise between two close friends made in passing at a suburban Sydney shopping centre resulted in one man receiving assets worth around $8 million, even though there was no formal written agreement. So how can a promise made years earlier end up carrying so much legal weight? What happens if someone promises, you'll inherit something, but their will says something different, or you never make it into the will at all? Joining me today is Duncan MacDougall, Senior Associate in Estate Litigation at Attwood Marshall Lawyers. Duncan, good afternoon to you.
Good afternoon.
This story has certainly caught our attention. It wasn't really about a disputed will. It's centered on a promise between two close friends and a handshake. Can you explain what happened there?
Yeah, so it's an interesting one where, again, it wasn't really a dispute about what the will said, because in this case, there was no will.
Right.
So what normally would happen is what we call intestacy. So as if the deceased because the deceased did not have a will, it's distributed down a list of eligible beneficiaries who could potentially receive the estate under legislation. So that's generally spouses, children, parents.
People who are related.
Exactly. And in this case, I understand that the closest living relative was this long distance cousin that was in the works.
Okay.
So they were entitled to it under intestacy.
Under law.
Yeah, under law. However, this close friend on this handshake deal kind of had this reliance on this promise: take care of me, and everything will be yours.
Okay. So there's background there in terms of he was caring for this friend?
Yeah, so there's a bit of a reliance there. So
Okay.
over the years, they assisted with the deceased. This person retired early. They didn't move toward, I think it was family and friends. There's long-term evidence of ongoing care, some sort of financial support.
Okay.
So it's not just, oh, they told me this,
Yeah, okay.
and I get this outcome.
Right.
It's showing that they relied, and then all of a sudden there's a big detriment to them over time. And what we call as lawyers proprietary estoppel. So there's this avenue there where, yes, the law says one thing, but you've got some rights here. And that being said, it's not an avenue we see often. It's a rare bird
because it's hard to prove.
Yeah. It's going to come down to a mountain of evidence. A court just doesn't award these sort of things just based on a handshake. Typically, they're going to have to show, well, what kind of things did you do, and what kind of detriment did you receive here on reliance of this promise.
Okay, because I guess you'd sort of assume that if something isn't written down, because often we speak about, when you write down your wishes, even on a serviette, it doesn't count. So in this case, it's a verbal handshake. So if something isn't written down, it doesn't count. How can a verbal promise then sort of sometimes become legally enforceable?
Yeah, so I mean that's the big thing is we always hear, make sure your wishes are written.
Right.
Make sure agreements are in writing.
Yeah.
These verbal sort of agreements, again, it comes down to, was there a detriment and was there a continuing reliance there? Is the biggest factors, because without that, it's simply
too hard to prove.
It's too hard to prove. So all these sort of things like financial records, emails, text messages,
they were all produced and used.
Yeah, and these sort of things will constantly be used to produce a bit of a paper trail, a bit of a history of maybe witness these sorts of things. What did they give up in life in order to assist this person?
As always, if you've got a question for Duncan MacDougall, he's a senior associate in estate litigation at Attwood Marshall Lawyers. Duncan is on hand to give you some help, some assistance. 0499 880 882 is the text line. Of course, you can call through on the 4BC open line thanks to Watch Smoke Alarms, 133 882. Paul from Springwood has texted in. Duncan, I wonder if you can help with this question. And it says, can my deceased dad's executor, the public trustee, be changed? I'm power of attorney for my mum, but she has dementia.
Well, it potentially depends on several factors. One being whether or not the public trustee has been appointed under what's called a grant of probate. So yes, they're maybe nominated under a will. It's another thing, do they actually have a grant, which is that court stamp of authority to say, yep, that's a valid will and that's an entitled person to administer this estate? Whether they've done that process already or not, it might be a bit hard to do so. But if there's other people who may be eligible, but and the public trustee is willing to renounce their role in favor of, say, a child, another family member, perhaps, who's would be able to administer the estate, then that could potentially be a possibility.
Okay, I hope that answers your question, Paul. If you've got any questions around estates or wills, please text them through 0499 880 882. I just wonder whether or not you have seen a case similar to this handshake agreement. Is there anything that you've witnessed a similar situation arise between family members?
Yeah, where I see it often is things like, for instance, perhaps a family farm. You see it all the time where one child decides to go live with mom and dad and assist with the upkeep of the farm, upkeep in their personal health as their health deteriorates, all these sorts of things, throws money into renovations, and then other families go all about their careers. You come down to the time of passing, all of a sudden it's an equal distribution under the will, which would appear fair, but over the time, there's this reliance saying, well, look at all these things I did for you, and to some sort of detriment. Now, there's all other sorts of rights there that they may hold, depending on if they're eligible people. So, for instance, a family provision claim might be a better and more streamlined process to pursue versus this simply just relying on this promise, because you may not have enough evidence to support that fact. Whereas there's this mechanism in the law where a family provision claim might be more in line of something to pursue as long as you can demonstrate need for further provision.
I think in this case and so many cases that we speak about, I think it's the thing to be prepared, to engage the right people to help, so that makes sure that you don't end up in one of these disputes. That would be the sort of general advice that you would give.
Yeah, and to make sure everything's streamlined to a similar direction. So all your promises, all of your estate planning documents all point in the same direction. So at the time of death, there's not one promise here. There's not a reliance here. There's not a will that says something completely different.
Yeah.
It just creates less headache down the path. Whereas if you've got everything streamlined, and that's where estate planning comes into a place, there's could be, and when you're having those conversations with your solicitor, the solicitor will ask you questions about the family dynamics. Who's assisting you? Who's making payments? Who's been doing these sorts of things? Just to get a bit of an idea of who's who in the zoo and any sort of risks that may exist at the time of your passing.
And your wishes are lived up to, I guess. Thank you so much, Duncan MacDougall, as always, joining me for the Legal Lowdown, Senior Associate in Estate Litigation at Attwood Marshall Lawyers.